Hello and welcome to Video 2, Giving Legal Notice of a Guardianship Case. After you file a petition for guardianship of a minor child, the next step is to ensure that every person that has an interest in the case receives proper notice. Notice requirements are very specific. If a petitioner does not notify the required persons in the proper way, the judge will delay the case until you fix the mistake. As a rule of thumb, err on the side of giving notice to anyone who seems like they may qualify under these rules. Notice is about fairness. If someone who has an interest in the child's well-being is not notified of the guardianship proceedings, a judge may be hesitant to grant the guardianship. Let's first discuss who should get notice of the guardianship case. As a general rule, you should provide notice to anyone who is actively involved with the child and would be interested in the guardianship. There are 4 specific rules. If the child is 14 or older, the child must receive notice of the case. The parents, if living, must receive notice of the guardianship case. There are special rules about providing notice to a father if he was never married to the mother, or if he would meet the requirements for termination of parental rights. Anyone who acted as the child's primary caregiver during the 60 days before the date of the petition. De facto custodians must receive notice. A de facto custodian is any person who has been a primary caregiver and financial supporter of the child and who has resided with the child for at least 12 months during the child's life, or 6 months if the child is less than 3 years old. Now that you know who is to be notified of the guardianship case, the next question is how to notify them. To give notice, you must send every interested party a copy of the guardianship petition you filed with the court and a copy of the notice that includes the time and place for the guardianship hearing. This notice must be given at least 14 days in advance of the hearing. To be safe, it's best to notify them as soon as you can. There are 2 ways to deliver these documents to interested persons. First, you can mail the documents to their residence or office. Since it takes time to deliver, you must mail them at least 17 full days before the date of the hearing. Second, you can have the documents personally delivered to them. Regardless of how you choose to give notice, there is one final but very important step to remember. After delivering notice, you must sign and file a document with the court called an affidavit of service. The affidavit tells the court that notice was properly delivered to every interested party. It is the only way to prove to the judge that you correctly followed the notice rules. It is the petitioner's duty to ensure that every interested party receives notice. If you are having trouble finding or identifying a person who needs notice, you can request permission from the judge to give notice by publication. This involves filing a motion and affidavit with the court to publish notice in a newspaper in the county where the guardianship case is located. One final thing to keep in mind is that notice is an ongoing duty. If any interested party does not waive their right to receive notice, then they need to be given not just the initial petition and notice, but every other document filed during the course of the case. To reduce this burden, it may be wise to include a waiver of notice document with the initial documents you deliver, which an interested party can sign to tell the court they no longer need notice of the case.